Good afternoon, everyone. My name is Ola Peneva, and today you are joining us for our webinar, Implementing the EU Forced Labor Regulation. Before we start with some presentations, I will just make two messages, one in English, one in Bulgarian. For those of you who are willing to follow the translation in Polish and in Bulgarian, you can just tap right on the three dots where it says more, and you can see the English, Spanish for Bulgarian and Polish for Polish. Ще го кажа това и на български. Ако ще следвате тази презентация, този вебинар на български язик, ще имате възможност да го направите на канала, който е за испански. So I'm going back to the presentation. Good afternoon, everyone, and thank you for joining us. It's great to see such a turnout for this topic, for this important topic. This webinar is organized by the Polish Institute for Business and Human Rights and the Bulgarian Foundation for Business and Human Rights, and sponsored by our colleagues from the European Coalition for Corporate Justice, and we're quite grateful for this opportunity to talk on such important topic. For those of you who don't know me, my name is Ola Peneva, and I'm the founder and the director of the Bulgarian Foundation for Business and Human Rights, an organization that is based in Bulgaria. We specialize in working on business, human rights, and more on gender. One of the most current topics for us at the moment is, and one of the projects that we're currently working on, Embrace project, is on labor exploitation, and also the topic of forced labor is becoming more and more current. So for what we've done for you today is, as you know, we've extended the time just because we've had quite a lot of interest in this topic. We have 4 really important and valuable contributions, interventions from our presenters, for which I thank you. This webinar will be recorded, and you also have opportunities to ask some questions after the presentations of our speakers. I wanted also to say that if you have any questions, we can ask them in the chat. And now I will leave you in the hands of Ms. Beata Faragic, who is the co-founder and president of the Polish Institute of Business and of Human Rights and Business. She's also a member of the EU Forced Labor Expert Group, and she'll be moderating this panel. So Beata, thank you.
Thank you very much, Olia, for this very kind introduction and for also doing some of the housekeeping rules. Just before I start and go into the moderation, just to say also in Polish for some of the Polish participants that we do have translation into Polish and from Polish into English available. So if you go to the lower bar, you will be able to change it. So just switching for a moment to Polish. Dzień dobry wszystkim. Ponieważ ten webinar będzie prowadzony głównie w języku angielskim, mamy zapewnioną tłumaczenie na język polski, więc jeżeli chcą Państwo korzystać z tego tłumaczenia, proszę spojrzeć na dolną linijkę i tam będą Państwo mogli wybrać opcję języków, jakie są dostępne w tłumaczeniu. Pod językiem hiszpańskim kryje się język bułgarski.
The relevant language and just to explain that we have.
Przechodząc już do naszego dzisiejszego spotkania, nasze spotkanie.
So moving on to our meeting, I want to say that.
And I apologize for a moment because I probably am on the wrong language, so I can hear the translation, which is a little bit confusing. Apologies for that. Yeah, I think now I should be fine. So. Today's meeting is dedicated to the EU Forced Labor Regulation and how it will be implemented both across the whole EU, but also specifically in Poland and in Bulgaria. But before we move into the Forced Labor Regulation, I think it's important to remind us what forced labor is in general. So forced labor as defined in the ILO definition of 1930, is basically all work or service which is exacted from any person under the threat or of a penalty, and for which the person has not offered himself or herself voluntarily. And I know that Ben will be kind of providing us a little bit more of the intro, but I think it's important to remember that we have those three elements, that we need to have an element of a work or service, which can be any type of work happening in any sort of activity, industry, or sector, including in the informal economy. We need to have this element of a menace of penalty, and it's important to remember that forced labor does not have to include force. And we need to have this element of involuntariness, where the person cannot be deceived into taking work also. So those three elements are really crucial when it comes to the forced labor. It's also important, I think, when we'll be to remember that there are also some other terms that you'll come across in when reading about forced labor. You'll come across terms like modern slavery, trafficking in human beings for the purpose of forced labor. You'll come across the phrase labor exploitation. So just to put it in context, modern slavery is basically an umbrella term which covers also human trafficking, forced labor, debt bondage, forced marriages, slavery, and other slavery-like practices. It was first coined around like 1990s, first introduced in national legislation by the UK in the Modern Slavery Act 2015, but it's basically a much broader term than forced labor. Then we have also trafficking in human beings, and this is a term which is defined in international law, and it is basically a criminal offense where a person is deceived or the person's vulnerabilities or dependency is used to place this person in a situation of exploitation, such as forced labor or sexual exploitation, or some other forms, which we could continue to list. And then when we go to labor exploitation, it's again an umbrella term which refers to the work under very poor terms of employment, long hours. It includes underpayment, unsafe working conditions, and there are also very often in such situations, people have very few alternatives to seek other employment, and thus are much more vulnerable to be caught in such situations. Luckily, over the years, states started to introduce both at the national and international level various legislation to address those issues, which is important, particularly because we see a huge increase when it comes to the number of people who are affected and who are currently experiencing both kind of more broadly modern slavery, but also specifically for our topic today, forced labor. So when it comes to the modern slavery, we've seen the increase of around 10 million from 2016 to 2021. And out of those 50 million people that are in modern slavery at present, 28 million are actually in the forced labor situation. So it's not a minor issue. It's not an issue that is affecting only global South countries. It's an issue which is growing also in Europe. And therefore, it's really great that we have seen EU kind of joining some of the let's say EU developing regulations at European level that will help us to have kind of more uniform approach to tackling the challenges with which we are currently faced. This is not to say that before there were no tools or no guidance for companies. Kind of from the Polish backyard, we can always point to the publication developed by a multi-stakeholder group in collaboration with the Ministry of Funds and Regional Policy, which basically is a guidance for companies on how to identify and prevent forced labor, which basically takes the company and provides it with tools for every stage of due diligence process. And as Olia already mentioned, there is also currently in progress the Embrace project funded by the EU again, through which also a number of different tools will be developed, including standard operating procedures and online training activities, as well as an online grievance platform, which has a chance of providing victims across different countries with one place to go to find information on how to register their complaint and or learn about the remedy venues available in a specific country. So as I've mentioned, we will be going through today the forced labor regulation. So we'll look into the key requirements and implementation developments in individual countries, but also across Europe. And also we'll look into what the European Commission is currently doing with this respect. We'll have also insights into the EC guidance and the role of the due diligence under forced labor regulation. And then this kind of more presentation section will be closed with 2 presentations from the public administration officials from Poland and Bulgaria. So we'll have this insight into how the implementation of the forced labor regulation currently progresses in Poland and Bulgaria. And then we'll have around 15 to 20 minutes for Q&A at the end of our webinar. We have with us 5 really fantastic speakers. So we'll be starting with Ben van Paperstraate from Anti-Slavery International. And Ben is a senior EU advisor for Anti-Slavery International at the moment, but he was working with UNI Global Union and Industrial Global Union in the past, for example, on the implementation of the Bangladesh Accord. He has also advised organizations such as European Center for Constitutional and Human Rights, the Freedom Fund, SOMO, just to name a few. And his expertise covers corporate accountability mechanisms, mandatory responsible business conduct laws such as CSDDD, and of course, forced labor regulation. And Ben is also a member of already mentioned EU Forced Labor Expert Group, which is providing advice to the European Commission. And I think it's important also to mention that Ben has also worked on sustainability in instruments of the EU trade relations, including the CEP complaints against Peru and Colombia, and the Cambodian everything but arms investigation. And this is this very practical dimension, which kind of is very important when it comes to designing any sort of guidance or interpretations. Our second speaker, second and third speakers are from European Commission. So we are joined by Sherban Stercu from DG GROW and also Björn Sawyer, also from the DG GROW, who will be telling us what actually we can find in the European Commission guidance and also how the Commission itself will be approaching the enforcement of the forced labor regulation. And then we will be joined also by Marta Gromnicka from the Ministry of Development and Technology, and specifically the Technical Law Unit, which is in charge of the implementation of the forced labor regulation in Poland. And she has also has been involved also in the negotiation of the forced labor regulation before and currently is engaged in its implementation in Poland. And last not least, we are joined by Ernesta Ruseva from the National Commission for Combating Trafficking in Human Beings from Bulgaria. And she's an anti-trafficking expert with more than 15 years of experience in developing and implementing national anti-trafficking policies, international cooperation, and victim protection. And currently she's working to strengthen victims' identification and protection mechanisms, prevention, capacity building initiatives, and institutional cooperation. And I should perhaps also add that Ernesta is also an expert who is involved in the work of the Embrace project, bringing in this very valuable expertise to the work and to the activities that are currently ongoing with regards to development of the trainings and also standard operating procedures for the companies. So I'll stop here, and I have the pleasure of handing over the floor to Ben, who will introduce briefly the forced labor regulation and will also provide us with some of the insights as to the slightly broader picture than just the European one. So Ben, over to you.
Thank you very much, Beata. I'm going to share my screen. So I hope you all see this very well. I see.
Yes, we can see it very well.
Perfect. So indeed, my name is Ben van Peperstraete, and as already mentioned by Beata, I'm a senior EU advisor at Anti-Slavery International. First of all, I do want to really thank the organizers of bringing us together to talk at this crucial moment about this crucial piece of legislation. So it's a really opportune moment to be here together. So looking forward to the seminar or the webinar as a whole. I'm here going to lay the ground on the EU forced labor regulation itself. So I think building on what Beata already said, like the first question you need to ask is what do we talk about when we speak about forced labor? Because this is where the instrument aims to put a dent in it. And then we immediately, the most central definitions, there's a couple of definitions going around, but the most central one is provided by the ILO. That's all work or service which is enacted from any person under the menace of any penalty and involuntarily. So you have basically 4 elements to this definition, namely, doesn't really matter what type of work it is. It can be employment, it can be a private contractor, it can be a home worker. It doesn't matter what type of person it is. It can be a citizen, it can be a migrant, it can be a child. Any person does. And then to really talk about forced labor from an ILO and international labor law perspective, we always need 2 components, namely there needs to be a threat or a menace that there is going to be a penalty. And that can be very broad. That can be very explicit, like somebody holding a gun against somebody else's head. But it can also be very subtle. It can be about potentially threatening family members. It can be of using certain knowledge into a certain advantage. It really needs to be understood from the perspective of the person in forced labor. So, for example, let's say that the person, and I think it's a very good example, a person who believes in witchcraft, there the threat of bewitching that person is a credible threat. It's not necessarily a credible threat for everybody here on the webinar, but for that person, it's a credible threat. And that's what counts. Whatever the threat is, whatever the form is, it needs to be credible from the perspective of the person. So that's the first pillar, the threat or the menace of a penalty. And then the second is that that person has not offered him or herself voluntarily. And here, the same thing, the ILO, the supervisory mechanisms have interpreted it very broadly, in the sense that if you, for example, are a Bangladeshi migrant and somebody promises you work in Abu Dhabi, and in the beginning they say, oh, but come to Abu Dhabi, you will earn 3,000 euros a month and we will give you a house, etc. And then once that person comes in Abu Dhabi and it turns out that the salary is not 3,000 euros a month, but only 300 euros a month, and the accommodation is not a penthouse in the Burj Khalifa, but a very shabby sleeping room, dormitory. That is also a form of not voluntarily, that if the conditions don't match, is an example on how a person could be involuntarily in employment, because it's not the type of employment that you initially signed up to. So a menace of a threat, or the menace or threat of any penalty, and involuntariness, those are really the 2 pillars on which this definition stands. And both of them need to be interpreted very, very largely. But again, we're talking about a lot of different situations, lots of different instances, lots of different ways that these can materialize in real life. And to help unpack that a bit, the ILO has developed 11 indicators, and I say that they help increase visibility. Because what the ILO at a given moment in time did is they looked at a lot of cases of forced labor also under their own supervisory mechanisms. And they said, okay, can we distill specific red flags from that are most likely to be an indication of forced labor? And here you see them. They distilled 11 of them: abuse of vulnerability, deception, restriction of movement, isolation, physical and sexual violence, intimidation and threats, retention of identity documents, withholding of wages, debt bondage, abusive working and living conditions, and excessive overtimes. These are the 11 that they came with. Does that mean that if you come across one of them that automatically means that there's forced labor? No. But once you see one of these indicators, there's at least a high risk that there is forced labor. And so a more deep investigation is warranted to look whether or not those two elements, namely the threat or menace or of a penalty and the involuntariness, are present. And you will see also a bit that some of these indicators are very precise. Take retention of identity documents, it's a very precise indicator. Debt bondage, same thing. Whereas abusive working or living conditions can be actually quite broad. So it's really a toolbox to help you identify forced labor, to identify instances where you need to look deeper for forced labor. But it also demonstrates how forced labor can actually take many forms and shapes. And I think that's the most important, because sometimes forced labor comes really in places where you wouldn't necessarily expect those. These are just general indicators. It may very well be, let's say that you're a company active in a specific sector, that there may be also additional indicators or red flags or tools available for your sector. So, for example, in agriculture or in construction or in seafaring, you might want to refine this. But this is something that the ILO developed sector agnostic. And also, what the ILO has increasingly done work on in the last decade is to also see that some of that some of that forced labor, even forced labor connected to supply chains, are not always private actors, but that also the state itself can be an actor of forced labor, and there we see state-imposed forced labor also getting increased recognition and visibility in the ILO system. So in some instances, it is not a private actor that causes the forced labor, but the state. In a very narrow set of circumstances, the state can actually do that, but those are very, very narrow, well precise, well described in the ILO conventions. But there's also quite a lot of instances where states have taken much more generous use of their own power to put people into forced labor. And also these instances can actually sometimes find themselves in your supply chains. So you may or may not, if you're a company, be linked to that, or if you're a regulator, you might see companies linked with instances where the state is a principal agent, and where these indicators also can take a bit of a different shape. As Beate already said that forced labor, modern slavery is it's a significant problem. It's a big problem. This map, which I think Beate also showed, because it's the same source, is basically an estimate of how much forced labor do we have. And this estimate happens every 5 years, just to get a bit of an iteration. What you see in the map are prevalence rates. So it's a percentage to the population. So it explains why, for example, North Korea is number one, because the ILO, as well as the Work Free Foundation, both consider everybody in the country to be under a form of state-imposed forced labor. But it also explains why, let's say, Russia, etc., also has a strong color, and maybe a country like China less. However, if we were to look in absolute numbers, because China is one of the biggest countries in the world, China would, of course, have more absolute numbers of forced labor in the country than Russia. So this map gives an indication, but you need to read it as percentages. So out of this work, the ILO and the Walk Free Foundation come to a conclusion that there is a bit less than 30 million people in forced labor. And of that, there's roughly 17 million in the private sector, to be found in the private sector. An additional almost 4 million in state-imposed forced labor. I already mentioned China. That's a place where there's a lot of visibility on state-imposed forced labor. But we are also seeing that in the cotton sector, for example, in Uzbekistan and Turkmenistan. But there's also places where you see incidental state-imposed forced labor. Think about prison labor in Brazil. There's also prison labor, of course, in the US, etc. So altogether, that also forms another 4 million. And a bit over 3 million people are children. So that's automatically one of the worst forms of child labor. What is also important is that roughly a quarter billion US dollars in illegal profits are generated because of the use of forced labor. That's a more recent strand of research that the ILO added to this estimate to demonstrate that forced labor also leads to illegal profits and that those are very, very sizable. And in the case of a more economic, macroeconomic view, also unfair competition. What I think is very troubling, of course, is that these figures are rising. So compared to the last time that the ILO counted, we see that there's at least 2.7 million more in forced labor. And also the illegal profits, they have actually doubled compared to the previous decade. So that means that the fight against forced labor could actually use an increase, which brings me to, I think, the next slide, namely that the logic or the intervention logic of banning products made with forced labor is really a new type of policy instrument that is becoming increasingly popular in the last decade, I would say. Being that the last century, for example, only the US had such an instrument. But the US has been quite aggressively looking to expand that instrument, that type of instrument, that type of thinking, like banning products made with forced labor, to other jurisdictions. And it first did that by convincing Canada and Mexico to do that as part of the North American Free Trade Agreement. But also in the last year, it quite aggressively leaned on a lot of other countries to do similar things. So that's why you now see that also Costa Rica has an instrument, Pakistan, Indonesia, etc. And also, equally, the EU in the last years has legislated such an instrument, so that it immediately adds 27 countries to the mix who are directly subjected to the regulation to prohibit products made by forced labor. And for other countries, namely the European Economic Area countries, so you see most visibly Norway and Iceland, they also need to take similar measures as part of their EEA commitments. So that means that actually in roughly a decade, we are changing really the narrative from only a few countries having a logic or an instrument to ban products made with forced labor to what is now a sizable chunk of the world and the economy.
And
So
Ben,
what-
oh yeah, perfect.
So what does this forced labor regulation then say? As I already mentioned, its purpose is to effectively combat forced labor and unfair competition. And it does so by prohibiting any offering or exporting of goods made with forced labor in the European market. So contrary to the other instruments, it's not only an import ban, it's also a market ban. It takes a very expensive scope, so it means that any product that is made making forced labor is in scope and prohibited. So it doesn't matter who sells it. Is it a company? Is it a natural person? Is it an association person? Is it a legal person? It's all products, no matter what you do, placing, selling, or exporting products or components. It does exclude services. And what is very important, it also uses the forced labor definition as defined by the ILO. And it also uses these ILO indicators as a way to further analyze this. And important, it doesn't really matter if it's in a direct supplier or in an indirect business partner 4 tiers away. It doesn't matter if the full product is made with forced labor or only a part. All of that is part of the expansive definition that the EU is using. How is the EU going to enforce this ban on products made by forced labor? Well, that really depends on where the forced labor takes place, because it basically the EU will have at minimum 28 competent authorities charged with enforcement. So If the forced labor takes place within the EU, so take, for example, Finnish berries, then the competent authority of that member state, in this example, Finland, will be responsible. If the forced labor takes place outside of the EU, so I took the example of, for example, cotton from Xinjiang, then the European Commission is the competent authority. This determines the leading competent authority, but sometimes in certain cases, you may actually need other competent authorities to work together. So it's the leading competent authority who informs the whole network about investigations. And so once a competent authority decides that there is forced labor, it sends also a similar message to the whole system in the EU saying, okay, I've determined that this product is made by forced labor. We now need to stop it. We need to take it from the market, and we need to stop it also from being exported. How does that then look? The heart of the beast, if you want. The EU has what I have now made in this graph, a 4-step or 2-step investigation procedure. Namely, that first, the competent authority has a notification. So that can basically happen because it receives a petition. So there is a central point where everybody can say, I think that there is going to be forced labor in this field or in that factory, etc. But it can also be that a competent authority starts from its own initiative based on other signals it got, such as the risk database, which we will mention further, certain risk indicators, previous decisions, information of other competent authorities, or just consultation with relevant stakeholders. So either out of its own motivation or in response to a submission of information, a competent authority will say, okay, I've been notified. We will appoint a lead competent authority based on where the forced labor is taking place. And that would trigger a preliminary investigation. So this is a very relatively lightweight part of the investigation, where the objective is really to answer the question whether or not there's objective verifiable information to suspect the likelihood of forced labor. You don't necessarily need to prove it. It's sufficient to have that objective and verifiable information that suspect a likelihood of forced labor. So do notice the double suspicion there. So again, it can be on its own investigation. It can be based on risk factors. It can be on any other elements of third parties, including stakeholder consultations. Let's say that's
just one more minute, Ben, please.
Yeah, but I'm wrapping up. Let's say that the competent authority has, in its preliminary investigation, concluded that there is no likelihood of forced labor. Then the investigation steps there. However, if the likelihood is there, it goes into the full investigation. And there, the lead competent authority goes much more deeper, looks at all kinds of information, including provided by business. It can do inspections, it can do another round of interviews, and any other information that it finds to really establish whether or not the product is made by forced labor. If at that moment in time, the competent authority says, okay, I have enough information and I can establish that the product is made by forced labor, then it comes to a decision saying that the product needs to be removed from the market. And that decision immediately goes to all the custom authorities who will then implement it. So that is the structure of the investigation and basically the heart of the regulation. To help that, there is a supportive measure, and that's all been bundled in the forced labor single portal. So it's what I mentioned already, central point for submissions. There's also information on competent authorities. There's guidelines which the Commission will after me talk about, so I won't really talk anything about there. There's a risk database which is supposed to come out last month, but is still in the works. And I also leave it upon the Commission if they want to talk about it. And there's also a list of other relevant public information sources. And for those who've already visited the forced labor single portal, there's also going to be a whole set of supportive measures, such as webinars, including sectoral webinars, etc. So that's a whole package for the EU to actually up its game in the fight against forced labor. And I, for my side, already thank you very much for your attention.
Thank you very much, Ben, and apologies for pushing on. We do have some questions already in the chat, but I'll keep them because some of them will be answered basically already in the presentations of our next speakers. And I want to hand over now to Szerban Stierciu and Björn Sawyer from DigiGrow, who will provide us with a bit of the overview how the Commission is seeing its role, what are the plans of, and what we can find in the European Commission's guidance. So over to you.
Yes, hello. Hi, everyone. Thanks, Beta, for organizing this, and thanks, Ben, for setting up the context. We'll focus here a bit on actually what we are doing, how we are preparing for applying the forced labor regulation. So as Ben already mentioned, we have, let's say, 4 key elements that pertain to a forced labor regulation. And the first one, like Ben also mentioned, this is a market ban. It's a product ban. So it's a ban on the EU market for the sale, import, and export of products made available on the EU market, which are being produced using forced labor. Now the distribution of cases is the Commission, European Commission, will take care of the cases of forced labor that occurs outside the European Union. And then we have member state competent authorities that will take care of cases where forced labor occurs within the European Union. Now the bans will be quite on specific products, so we have quite targeted bans based on comprehensive dedicated investigations. So it's not necessarily a blanket ban, but will be quite targeted. And we'll look at all products and all types of forced labor. Now in relation to this, also all products, just to mention that the regulation applies to all products that are placed or made available on the EU market as of December 2027, well, more specifically 14 December 2027, even if the products or their components were produced or imported into the EU before that date. However, it does not. The forced labor regulation will not cover the withdrawal of products that have already been sold or reached the end users. Now, again, a bit overlapping here what Ben said. So we prepare different work streams and packages for different stakeholders. The first one is the Forced Labor Singapore portal, which we already launched almost a month ago. You can find a lot of information there, including lots of information on guidelines and the whole investigation process and the steps the competent authorities might go through, and also a lot of information that is relevant not only for competent authorities, but also for different stakeholders, companies, civil society, and so forth. We also provide a set of support measures for SMEs, and also, like Ben mentioned, there will be a public database of forced labor risks, which is upcoming, and will also be the single information submission point where different petitioners can actually submit complaints about any information about forced labor occurring in different industries and products. Now, with regard to the guidelines, so the guidelines are quite comprehensive, but we try to reach a balance there in terms of not being overly prescriptive, but at the same time also containing a lot of information that main aim is actually to guide different stakeholders in how the forced labor regulation will actually apply from the end of 2027. So this is more or less, these are more or less structured around 5 main components. The first is the scope of the regulation. So this refers to the products and companies being covered, key definitions of forced labor, also the forced labor indicators that Ben already talked about to some extent, and also referred to in the next slide. And then we have the investigative process, which more or less deals with prioritizing cases. Then we also have the risk-based assessment approach, which is also in the forced labor regulation, Article 14. I'll talk about this in a bit as well in the next slide. the investigative process will be at will contain different stages. I will show you a graph in the next slide as well on these different stages. And then you have enforcement and penalties, due diligence. This is for economic operators, so guidelines for economic operators, and then submission of information and how petitioners can actually submit information and what type of evidence is actually accepted via this submission of information portal. Now, regarding the first part, the scope of the regulation. So, as Ben mentioned, we're actually covering all products. We're not covering services. We're having all products made in whole or in part with forced labor at any stage of extraction, harvesting, production, or manufacturing. So, as I said, excluding services. So, we're covering all products across the entire supply chain, from extracting raw materials to the end processing and the final user. We're also covering all geographic areas, whilst we are recognizing that some areas may present a higher risk of forced labor, simply because we are distinguishing between privately imposed forced labor and state-imposed forced labor. And then also we're covering all companies selling on the EU market or exporting from it. So these might be manufacturers, importers, exporters, distributors, retailers, online sellers, and so forth. So the scope of the regulation is quite broad, as you can see. And for this reason, we also need a risk-based approach where we assess a level of different forced labor risks across different sectors and product groups, so that we manage to prioritize different cases. Now, with regard to the investigative process, this is structured around 5 main stages. We have an initial assessment of potential violations. So this is where we actually use our risk-based approach and the 3 criteria that I'll mention in the next slide. Then we have a preliminary phase, which is actually when we identify, let's say, high likelihood of violation of the forced labor ban. We enter into dialogue with the economic operators that are linked to those products that we identified as being at high risk of forced labor. And now after the preliminary phase, we go into formal investigation. If we find that there's a so-called substantiated concern, my colleague will talk more about this phase. And after the formal investigation, if the authority establishes that the product has been made with forced labor, we end up issuing a decision, which is actually a market prohibition, whereby the economic operators are obliged to withdraw the products in question and dispose them. And finally, we have the enforcement phase, which is at the EU and also at the EU level and also at the border of each member state, depending on the case being analyzed. Now, with regard to so this more or less relates to the first, let's say, first 2 stages, so the preliminary investigation and the initial investigation. So kind of the first 2 phases of the investigation process. We have so-called risk-based approach. So this applies to, we have 3 criteria, which are based in the regulation, which applies to identifying products or product groups to enable us to identify which of these product groups, because the regulation is so broad in scope, which of these product groups are actually at risk from forced labor, and which of these product groups are actually at high risk of forced labor. And from this respect, we have 3 criteria. One is the scale and severity of suspected forced labor. And the scale can be prevalence rate, like Ben mentioned, can also be the absolute number of people in forced labor. Severity can relate, for instance, to systemic or systematic forced labor risks, as you have, for instance, in the case of state-imposed forced labor. But can also be other types of other ways of measuring severity. And the second criterion is a quantity or volume of affected products that are placed or exported from the EU market. So this actually relates to let's say the value of imports of the respective product group into the EU, if the forced labor is occurring outside the EU. Also can be actually the absolute quantity in terms of physical quantities, like tons of certain products being imported into the EU. And the final criteria is the share of the product made with forced labor, because as mentioned before, we're looking at the entire supply chain. We're not looking only at at the final product, but actually looking at the different components that might have been made with forced labor, and to what extent those components enter the supply chain for a given product group. So we're looking at the extent to which forced labor occurs across the entire supply chain of a product group, from upstream activities like extraction of raw materials up to downstream activities. At the same time, so these are the three main criteria, which are also in the forced labor regulation, which apply to products for identifying and assessing the risks related to the products. Then we also have some elements that we need to consider when identifying companies and economic operators that are linked to these product groups. Now these elements are grouped into three main categories. The first relates to the proximity of the, let's say, economic operator to the forced labor. So to what extent that economic operator is very close to where forced labor is actually occurring? Is it actually in its operations, or is it actually upstream or downstream of its own production process? Then the second one is the leverage. So to what extent the economic operator is capable of mitigating and ending forced labor. And then the third and to what extent is also capable to influence the mitigation and ending forced labor in different parts of the supply chain. So even if it doesn't not occur in its own production processes, it might have a power or leverage in terms of supply relationships in mitigating forced labor, let's say, much upstream of its production processes. Then the third one, which is linked to leverage, is size and economic resources of the involved economic operators, because the bigger the size of the company, for instance, the more, roughly speaking, the more power, the more leverage it has in terms of actually being able to do something about ending forced labor in its supply chain. And finally, we have we also have to consider the complexity of the supply chain. As you probably know, for some industries, market sectors, etc., supply chain is extremely complex. You might have hundreds of companies being part of the constellation of economic actors producing a certain type of product. So we also need to consider this complexity of the supply chain, and the complexity of the supply chain is another way of saying that the more complex the supply chain is, the more likely, roughly speaking, that forced labor may occur somewhere in that supply chain, simply because it's more complex and more opaque. So we also need to consider this element in our assessment and prioritization of cases. And I think that's it from my side. I'll let my colleague Bjorn talk about the next phases of the investigation process.
Yes, thank you very much, Sherban. Good afternoon to everyone. And I will build a bit on what Sherban just mentioned on the different economic operators, and focus very much on how this investigative process would actually translate for the different companies. Maybe one interesting element to mention is that, as you have understood from both Ben and Sherban presentation, is that the approach of the regulation is very much focused on products. But it's quite difficult at the same time just to test the product in isolation and check at them and say, okay, this product was made with forced labor. So we need, so to speak, proxies, and that's the reason why in the course of the investigation, we will make intervene the different companies that might have actually sold or exported those products. So there are basically two moments where companies can be potentially contacted. The first one is in the preliminary phase, and there different competent authorities might check indeed whether there is a substantiated concern, and for that, they will request information, notably on due diligence. But of course, I will come back to it because it's on voluntary basis. unless, and this is an important exemption, unless there is a risk of jeopardizing the process. And this is only applicable, of course, to the preliminary phase of the investigation, because there is the right to be heard throughout the process. So you won't have a decision applying to economic operator without being consulted beforehand in the process. But that being said, there is a possibility indeed to skip that part, just because you might have risk, for example, for the victims, but also to take into account um, the possibility of evidence disappearing, and colleagues will probably from member state will probably touch upon that as well, because in the EU there might be as well parallel criminal cases running. The second stage at which you will be as a company informed and heard is also during the investigation. And in some cases, but quite exceptional cases, you might have field inspection, probably routine checks in the EU in line with existing procedures. But when it comes to third countries, of course, this is a bit more challenging because there is the question, of course, of sovereignty. In terms of information that can be requested, well, there is quite a wide range of accepted evidence. It can range from interviews, social audits, satellite imagery in certain cases, custom data, and so on and so forth. And something that might be also important to keep in mind is that the standard that will be required is an administrative standard and not a criminal one. So, of course, in terms of interplay with the criminal proceeding, for example, in the case of EU investigation, investigation led, sorry, in the EU, well, you see that the threshold might be a bit lower. That being said, the burden, and this is an important element, and Ben in the introduction mentioned the US system. Well, the burden is very much on the competent authority, so there is no such a thing as an automatic reversal of the burden of proof for certain product. No, it's really on the competent authorities to build the case. But of course, we need cooperation from businesses, and that's the reason why non-cooperation is also taken into account. So when we talk about non-cooperation, it can be a refusal, for example, to provide information, delaying on purpose the investigation, providing incomplete information, or just obstruction. So this is also a key message, is that if you were to be caught in an investigation, try to cooperate as much as possible, because cooperation might be in your best interests. And at the end of the day, the whole investigation, as in every case, will be built on all available facts. So not only the information that is provided by the companies, but also by the petitioners, by NGOs, victims, and so on and so forth. Just maybe for your attention, and this is a good kind of promotional moment for us. Indeed, we have launched the website that gathers a whole range of resources, but this is really to illustrate what you can find there, and also to really emphasize that attention and specific focus has been drawn on the case of SMEs. We know that most of our companies in the EU are SMEs, and that's the reason why we have tried also to explain the regulation in very simple terms, accessible terms, and also to kind of walk you through the different steps you should do in terms of getting prepared for the regulations. I really can only recommend you to go to the website. Probably also colleagues from national administration, we briefly touch upon that, but at member state level, you will also have support available through national contact points, but that's also, of course, will be gradually implemented. Maybe a word quickly on the decisions and what you can expect once this investigation is concluded, and if it concludes indeed that there is forced labor. There are two elements constitutive to the decision, and this is a bit related to what I've tried to explain in terms of product on the one hand and companies on the other. That as such, once a decision is issued, it's a product-based decision. So it will be a prohibition, as Sherban and Ben mentioned, on selling and exporting the products concerned on the EU market, and theoretically should apply to all economic operators, even those that have not been subject to the investigation. But at the same time, we know because of the investigation that we will, of course, identify some economic operators, and therefore you would also have within the same decision specific orders dedicated to those companies that have been subject to an investigation. And basically, they are of two types: withdrawal and disposal orders. And the regulation also here takes into account, as was briefly mentioned, the case of a product where you have only one part of that product that was tainted with forced labor, and the possibility for the company to actually replace that part. I will not go too much into detail for the interest of time about the different possibility that you have, but know that you have different, of course, ways to ask for a review, a withdrawal, or an appeal of the decision. They all have different legal consequences. But of course, here I invite you to go through the guidelines or the specific bits related to that, because I would like to focus maybe the end of my presentation on something that's, I guess most of you might ask, yeah, but what is then the link with due diligence, which has, of course, over the last few years gained a lot of prominence in comparison to the forced labor regulation in the kind of EU debates. And here, maybe an important element and probably the starting point is to understand that the forced labor regulation does not impose due diligence obligation. The forced labor regulation is really about an obligation of results, and due diligence in that context stays very much voluntary. But of course, and this is in line with the different international standards, OECD, ILO, UN guiding principle, that due diligence is a very effective way in certain cases to also demonstrate compliance during investigation, or at least to provide information. And some of you might be familiar with the kind of wheel that you see on the right hand side of the slide. It's basically the different 6 steps that are recommended by the OECD, and those due diligence guidelines issued by the OECD have celebrated last month the 50 years. So you see it's a kind of proven framework to help companies, including SMEs, to navigate a bit their supply chain, to better understand it, and also to prevent and potentially address some of the risk. And last but not least, I see that a lot of you and a lot of participants might more come from the business world, but I also take the opportunity to share a few information about the submission information, because you might also have people from civil society here. Of course, you will be a great partner in the course of the investigation. I think it has been demonstrated in other instances, and for example, also in the US, Mexico, and so on and so forth. But basically, my key message here is that all the submission will be centralized via the website, so the so-called forced labor single portal, and you will have a dedicated submission information submission points that will be operational the day of the entry of application, the day of the entry application of the regulation. And of course, feel free again to have a look on the websites, and also happy to take on specific question to it. And then finally, this is a bit the roadmap that you will see. We are more or less 18 months ahead of the entry of application. We are getting prepared, and I guess this is also the same message that the member states and the next speakers will pass on. And we are providing you with different resources, so it's good that we are raising awareness about the regulation, but also in the course of those 18 months, we strongly encourage you to start getting prepared, to browse all the different resources, and and try to engage with us, also engage with the member states there. That's it on our side. Thank you.
Fantastic. Many thanks, Björn and Sherban. And we'll change slightly the order now. So I'll be handing over to Ernesta Ruseva from Bulgaria to tell us about the developments in this country.
Thank you. Thank you, Beata. Can you hear me well? Thank you. Well, I was very much interested in, especially in the previous presentation, and I have my questions, but I'll leave it for a bit later. I'll try to stick to my notes because usually it is a challenge for me, but it is, safer for the audience. But what I was thinking during, especially during the previous presentation of the colleagues from the European Commission, is that when we speak about forced labor, specifically in the context of the regulation, we often think about the products. But before there is a product, there is always a worker. And because before the forced labor becomes visible in a supply chain, it usually begins much earlier with the deceptive recruitment, what the colleague from the anti-slavery shared about the definition, deceptive recruitment, debt bondages, confiscation of IDs, dependency on the employer, isolation, the inability to leave the job. And this is precisely where anti-trafficking authorities become, in a way, relevant. And that is why I'm included, in a way, in the working group at the national level, developing the relevant measures related to the regulation. Anyway, the Bulgarian National Commission for Combating Trafficking in Human Beings is the national anti-trafficking coordinator, the coordinating body responsible for developing Bulgaria's anti-trafficking policies, coordinating the national referral mechanism, supporting victims, and strengthening cooperation between public institutions because it is a collective body, civil society, and international organizations and other partnering organizations. So I'm particularly pleased to participate in this event today, organized by our partners from the Bulgarian Foundation for Business and Human Rights and the Polish Institute for Human Rights and Business. We have the privilege, as Beata mentioned before, that we have the privilege of working together within the framework of the Embrace project, which has become, I would say, an excellent platform for bringing together public institutions, businesses, employers, organizations, social partners, civil society, to address one of the most challenging forms of exploitation, labor exploitation. We're working together to improve prevention, identification, specifically related to trafficking in human beings for the purpose of labor exploitation. And many of the observations I will share today are actually, in a way, a result results not only of our daily work, but also in relation to this cooperation within the Embrace project. Well, I will briefly present three main issues that I have identified when I was preparing myself for this intervention. The trends that we are currently observing in Bulgaria, our national preparation for the implementation of the forced labor regulation, and one main thing also, why distinguishing between labor rights violations, labor exploitation, forced labor, and trafficking in human beings for the purpose of forced labor is essential if we want actually to implement effectively the forced labor regulation. Over the past several years, labor exploitation has become one of the most significant forms of trafficking in human beings at the international level, at the EU level, and we are observing the same at the national level. In 2025, for instance, almost half of all informally identified victims supported through the national referral mechanism were victims of labor exploitation. During the first half of 2026, it is quite the same. And we continue to observe an increasing number of reports involving third country nationals in Bulgaria, labor migrants who have their employment contracts, working most often in construction, agriculture, manufacturing, food processing, logistics, and domestic work. And many of them, they arrive legally, they have employment contracts, but in the same time, they gradually become trapped in situations related to exploitation or forced labor, excessive dependency on employers, documents retention, which is the main issue that we're observing, including in the most recent cases that we received, let's say, the last week. Non-payment of wages, excessive working hours, poor living conditions, restriction of freedom of movement, everything which is included in the brilliant 11 ILO indicators, I would say, also in the indicators included in the national referral mechanism of Bulgaria. But these situations rarely begin with a kind of an obvious violence. It is the same for sexual exploitation, for instance. Traffickers, they're using more soft, let's say, methods of involvement. But these situations, they develop gradually when people are already in the country of destination. That's why identification is really important, and early detection, it is really important. In the same time, I would say I'm not happy about sharing this, but anyway, it is true. Only a very small proportion of these cases, these situations eventually become criminal investigation for trafficking in human beings for the purpose of forced labor. I mean, specifically related to the cases of third country nationals, mainly labor migrants, but not only. We don't have a formally identified case since the beginning of the migration processes, but I wouldn't open this topic because it will, take all the
Yes.
time I have.
And I'm afraid we've got just 4 minutes left
Yes,
maximum.
I know. So this tells us that there is still a significant gap between exploitation as it exists in reality and exploitation it is recognized within the legal procedures. This is one of the most important lessons we have learned through the Embrace project as well. It has enabled us to work closely with labor inspectors, businesses, employers, organizations, as I said, the other social partners, I mean trade unions, NGOs, migration authorities, law enforcement agencies, and many other partners. And maybe the most valuable outcome so far has been the opportunity to build this type of common understanding about all the issues related to labor migration and labor mobility in a way, because every institution or organization sees only a part of the picture. Labor inspectors, for instance, they identify labor law violations. Migration authorities, they're focused on resident status and the vulnerability related to the resident status. Police identify indicators of trafficking in human beings, not only other type of crimes as well. NGOs, they gain the trust of the victims. Businesses, they increasingly recognize that ethical recruitment is also good risk management and responsible business as well, a sign of responsibility. And only when these perspectives are brought together, we can understand that what it is really happening. So effective identification and early detection is therefore impossible without a kind of a multidisciplinary cooperation. Another important lesson.
Ernesto,
Yes.
unfortunately, I need to almost stop here. We have just 1 minute. So just if you want to say what is the stage of the implementation of
I
ZFR
will. Well, all these
Thank you.
experiences have also shaped the national approach related to the preparations of the implementation of the regulation. We have a joint interinstitutional working group. It is chaired by the Ministry of Economy and Industry, and the Ministry of Labor. It is co-chaired by the Ministry of Economy and the Ministry of Labor and Social Policy. It brings together all the relevant representatives of the Ministry of Economy, Ministry of Labor, the Labor Inspectorate, the Ministry of the Interior, the Prosecutor's Office, Customs Agency, Market Surveillance authorities, the National Commission, special regulators as well. And so far, the group is focusing on several key areas: the mapping of the responsibilities related to the regulation, discussing the designation of the competent authority or authorities to be a focal point, developing mechanisms for interinstitutional cooperation and information exchange, analyzing the existing legal framework, and identifying the practical legislative gaps that should be addressed before the regulations become fully applicable. One important conclusion that has already emerged is that implementing the regulation is not simply a matter of market surveillance. It requires reliable identification of forced labor, coordinated investigations, close cooperation between labor authorities, law enforcement, prosecutors, customs, market surveillance bodies, and victim support organizations, which will finally effectively lead to an effective market surveillance. And from our perspective, the main thing that I would like to share, the last thing that I would like to share, is that it is really essential to distinguish clearly between labor rights violations, labor exploitation, forced labor, and trafficking in human beings for the purpose of forced labor, because these concepts, they may overlap, but they're not the same, they're not identical. Not every labor rights violation amounts to labor exploitation. Not every case of labor exploitation constitutes forced labor. Not every case of forced labor fulfills all legal elements of trafficking in human beings. So it is really important to clearly distinguish all these type of violations or criminal offenses and to adapt our approach.
Thank you very much, Ernesta.
Thank you.
To
Thank
stop
you,
it here.
Okay,
Sorry,
I can share. You can share. My speaking notes with because I didn't prepare any slides, so you can share my speaking notes with the audience if they'd like to receive it. Thank you.
Lovely. Thank you so much. And we move to our last speaker. So Marta Gromnicka from the Polish Ministry of Development and Technology will lead us through the developments in Poland. And just to point you that we've got already 2 questions in the chat, and colleagues from the Commission has already kindly replied to them. So I also want to point you to some of the answers already existing to the questions there. And feel free to add some of the additional questions in the chat. Our Q&A session, unfortunately, will be much shorter than we've planned, but now I don't want to extend. Ms. Gromnicka, over to you. Thank you so much.
Good afternoon. Following the presentation of the previous speaker, I would like to briefly outline the key aspects and current state of play regarding Poland's presentation for the application and enforcement of forced labor regulation. This is a landmark instrument in the EU approach to protecting human rights in global trade. From a member state perspective, including Poland, it represents both a constitutional and a strengthening of long-standing international commitments to eliminate forced labor in all its forms. Although the prohibition itself will apply from the 14th December 2027, the regulation is already partly in force. Member States and the European Commission are currently working on the preparatory framework necessary for its effective application. This includes, among the other, the designation of competent authorities, the development of enforcement mechanisms, and the establishment of the forced labor database and use of the ICSMS system module dedicated to the forced labor cases. From the Polish perspective, we fully recognize the importance of ensuring that those preparatory steps are taken in the timely and coherent manners. And the effectiveness of the regulation will be dependent not only on its legal clarity, but also on the practical readiness of the national administration to cooperate within a common EU enforcement framework. The definition of the forced labor used in regulation is aligned in the International Labour Organization Convention. Importantly, it includes the forced child labor. So this definition is intentionally broad reflect the complex reality on modern global supply chains, where forced labor risk may arise at different stages of production. For this reason, the regulation applies to the entire product life cycle, from the raw material extension through the manufacturing and processing to the final product placed on the market. It is important to underline that forced labor is, by its nature, often hidden within complex supply chain, frequently outside the territory of the European Union. However, its effects are directly felt within EU internal market. It is also relevant for countries such as Poland, where enterprises are deeply integrated into global value chains as both importers and exporters. In practice, this means that EU businesses will increase the need to access and manage risk linked to the forced labor in their supply chain. While the regulation does not introduce a standalone horizontal due diligence obligation, is clearly incentivizes companies to strengthen existing compliance system. Importantly, any due diligence efforts undertaken by economic operators may be taken into account by competent authorities during the investigation. On June 26, the European Commission published the guidelines on the implementation of the forced labor regulation. The guidelines provide important practical clarification for competent authorities and economic operators, particularly regarding the risk-based approach, due diligence consideration throughout the investigations. Polish consider those guidelines an important reference point to the development of its national implementation framework and for supporting businesses in preparing for the application, the regulation from December 2027. The regulation encourages full cooperation from economic operators. Transparency and engagement with authorities are essential elements on an effective enforcement system. Non-cooperation of the provision of the misleading information may lead to adverse decision. In Poland, political decisions have now been taken on the national implementation model. The Ministry of Economic Development and Technologies has been designated as the competent authority responsible for conducting administrative proceeding and issuing decision under the regulation. The enforcement of those decisions will be supported by the number of cooperating authorities, in particular market surveillance authorities acting within the respective areas and competence. We currently also establishing a dedicated working structure to support the implementation of the regulation at national level. This group will be focused on legislative preparation, coordinating between institutions and the development of practical guidance for economic operators. We intend to involve all relevant authorities engaged in enforcement and market surveillance to ensure a coherent and efficient approach. At the same time, Poland has already prepared preliminary legislative proposals supporting the application for the regulation. We actively analyzing national framework to ensure that the necessary institution arrangements, enforcement mechanism, and procedural provision are placed well before the regulation becomes fully applicable. We also see strong value in ensuring that implementation is not purely legal in nature, but it's also practical and operational. And this includes the development of a coordination mechanism between authorities and training and the effective use of EU-level tools such as ICSMS. Finally, it is important to emphasize that forced labor remains a global challenge requiring coordinated international action. The EU framework introduced by the forced labor regulation is significant step forward, but its success will depend on consistent implementation, cooperation between member states, and engagement with economic operators. Companies are therefore encouraged to bank preparation early, mapping supply chains, strengthening contractual aspect, improving risk assessment tools, and building internal compliance capacity will be essential steps ahead of 2027. It's also important to situate the forced labor regulation within the broader EU framework on responsible business conduct, in particular the corporate sustainable due diligence directive. While
Musimy powoli kończyć, jeżeli można
Uh,
minutkę.
yes. While the forced labor establishes a clear prohibition of products made with forced labor, but the directive CSDD introduced a more general obligation of large companies to identify, prevent, mitigate, and bring to the end adverse human rights and environmental impact of their operation and value chains. From the practical perspective, those two instruments are completely complementary. The directive CSDD provides the horizontal due diligence architecture, while the forced labor introduces a targeted enforcement mechanism focused specifically on forced labor risk in products placed on the EU market. It means that companies will increasingly rely on the same underlying tools, supply chains mapping, supplier engagement, risk assessment system, and so on. So, in other words, effective companies with the CSDD will be significantly support compliance with the forced labor regulation and vice versa. And
I'm afraid that I need to stop
yeah,
because we have just 7 minutes left, and I really would like to give at least a
thank
few
you very
minutes.
much.
So many thanks, Ms. Gromnicka, for this intervention and for sharing that who also in Poland will be in charge. So we understand that the work is ongoing, but it was decided that it will be Ministry of Economic Development and Technology, although supported with some additional institutions. So just to answer some of the questions that are already appearing in the chat. So once again, big thanks to all our speakers. And we did have some questions that already appeared in the chat. And many thanks for the colleagues for the speakers to have already replied to those, but we do have two which were not. So one is, in the context of the forest regulation, have any national implementing measures been adopted in the EU member states that specify, among other things, the competent authorities responsible for audits and inspections of due diligence systems, or establish the applicable penalties for non-compliance? In which countries, what are the identification numbers? I mean, I think it's a little bit preliminary, but if any of you want to answer this question, so that's the question one. And I think there is one more question. How precisely will a banned product be described in a banning decision? How real is the risk of changing of minor characteristics of a product in order to pretend that it's not a subject of a ban, which might be relevant in case of multi-year proceedings? in reality, how is the EU Commission going to force the entities outside of the EU to provide, and that's a question, second question, sorry, how the EU Commission is going to force the entities outside of the EU to provide information or consent for on-site inspections, particularly when we are talking in China. So because I know that one of the colleagues from Commission needs to leave soon, perhaps I'll just give you the space now to answer those questions, and then we can move to the other ones. And also from the EU market towards third countries, Ben is adding.
Maybe Beata, I can take the first one and try to give an answer to the second and third question, which are quite structural tension in the regulation. Indeed, so there is a list of competent authorities that is, I mean, a provisional list of competent authorities that is published on the portals, on the website. It's still under construction, to be honest, and we will try to present it in a more user-friendly way. But you can already filter when you click on contacts. You can already filter then by member states, so you should be able to find the relevant authorities that have been appointed by the member states in question. And I think that the Polish colleague already answered, and Ernesta also kind of between, I mean, if you read between the line, also give an answer on the upcoming competent authorities. Now, related to the decision and the product description, indeed, and I think that, again, I will refer back to the intervention of Ernesta, because the key issue is indeed to link the products with the forced labor. And here we won't have only identification element related to the product as such. We will also have, of course, information about the companies that are placing the product on the market, but also information about the whole supply chain, and including the stage of the supply chain where forced labor is established. And I think that in most cases, if we are able to just show basically where the product comes from, this gives enough information. I see Ben would like to complement that. Of course, in the case of state-imposed forced labor, it might be trickier to do so. Also, for your information, we are currently drafting an implementing act that will, so basically secondary legislation, that will specify the elements that will be contained in the decision. There will be a public consultation also on this very specific implementing act. So if you have any good idea on what should be the different elements to be contained to enable the identification of products, of course, feel free then to be consulted there. But there is, in a nutshell, it's true that the tension is very much about giving enough information to enable the identification and enforcements, and not being overly prescriptive, because then you would have a whole range of products that would not be caught. Now, related to the last question on how we will be able to have basically gather information from third countries. Well, there is, maybe we were not clear enough on that, but basically the main economic operator and companies that will be requested information from by the Commission or by competent authorities are European companies. Of course, in gathering this information that we are basically asking them, they will have to get in touch with their own suppliers. And there we fully appreciate, of course, the difficulty, especially in the current context, to sometimes get information from those third country suppliers. The only kind of teeth that we have is that if in that course of the investigation, we have an economic operator, European economic operator, that is acting in good faith and just telling us, well, we couldn't gather any information from our third country supplier, we might trigger it as a case of non-cooperation, not from the perspective of the company as such, but of course from the perspective of the third country supplier or third country governments if state-imposed forced labor is there. But I see Ben wanted to react, so Ben, over to you.
Exactly. Thanks.
Thanks, Bjorn. And it's really just to complement to the first question. I think the notion of product itself also has a degree of flexibility, because I think it will depend investigation by investigation how broad or how narrow a specific product is being defined. And so I think there the competent authority also does need to or will probably take some contextual notions to make sure that it's not as easily circumvented by changing a small detail to the product. So you could, for example, define a product really narrow and thinly, or you could go to a sort of higher level in a more general description, depending also what is probably the specific makeup of the facility where the forced labor has been found. Yeah.
Mm-hmm. Many thanks, Ben, for this. And we do have more questions appearing, but we are already, unfortunately, after the end of the time for the webinar. So just literally have two questions. One, which is probably very quick, is electric energy also considered as a product under the regulation? Björn?
No, no.
Okay, and then another question which came from another source. How about the buildings? What about the buildings that are built with the material which is made with products made with forced labor, like bricks or any other construction material? So will people be expected to, let's say, destroy this building, or what will happen?
That's a really difficult question that we have, and also since Ben mentioned it in the introduction, because we know that the construction sector is one of the sector at risk. The position of the Commission is no, or interpretation is that basically the workers there are providing a service, and also that the building is basically reaching end users. And once the building is once basically a product is reaching end users, then of course you don't have the regulation that applies. That being said, if in the core, if one of the inputs or raw material or elements that is used to build this building is made with forced labor, then in that case, we might have the regulation applying, but not on the construction site as such.
Perfect. Many thanks. And perhaps literally the last question. Would it be possible that a decision of a ban to would it be possible for a decision of a ban to complement criminal proceedings related to cases of trafficking in human beings for the purpose of forced labor if we have, for instance, already a pre-trial proceedings opened and additionally a ban under the forced labor regulation? Can it be used as an additional evidence in such criminal proceedings?
I think that will be a bit up to each national jurisdiction and national system in the EU to decide that. But it's true that there is a tension, not a tension, there is complementarity. We see complementarity in parallel proceeding between the administrative proceeding under the forced labor and the criminal proceeding. That being said, and we fully appreciate that probably the criminal proceeding will last longer just because the burden of proof and the evidentiary threshold is much higher. Also, it takes more time, and the purpose of both proceedings are different. But we appreciate, and I think that the regulation leaves a bit of room for maneuver there for the different member states in delaying as much as possible the first interaction they would have with the companies involved or concerned to ensure that there is no risk jeopardizing the outcome of the criminal proceeding. And here we received quite good feedback from other member states that are actually dealing with the same type of question. But it's also applicable to other pieces of legislation. You also have other policy areas where you have at the same time criminal and administrative proceeding. So we can definitely draw inspiration from there. Yeah.
Perfect. Many thanks. And Ben, I think you also wanted to add on this point.
Yeah, very quickly, because I fully agree with Bjorn that the concurrence rules will be different in each member state. So you need to look at that. But I think, and that's really to Ernesta's point as well, is that we will see this probably most likely in cases where there's both trafficking and forced labor, and you could sort of like see the two elements. And however, I think both proceedings will also often have different results. Under this instrument, the product is being removed and disposed of. On the other one, a perpetrator will be punished. And that's, for example, payment of a sum or spending times behind bars. So in that sense, they complement each other in those cases.
Perfect. Many thanks. And unfortunately, I cannot ask, well, we don't have time to go deeper into the due diligence and FLR issue. So I'll put a dot here, and perhaps we can organize another, perhaps a little bit shorter webinar just to focus on this issue, because I've seen the question like, what if the company doesn't have a due diligence process in place? And yes, FLR does not require it. But at the same time, when we look into all the elements that were listed in the response, when you kind of know what due diligence can comprise, actually they all can form part of the due diligence. So I think it's a bigger question that we can look in detail in the future. But for now, I would like to thank all of our speakers for your really very interesting interventions and kind of shedding much more light on the forced labor regulation and the guidance itself. Also, many thanks for the speakers from the public administration for giving us a little bit of the insight into where the developments when it comes to implementation at the national level stands. And I do hope that we'll be able to have another discussion on the related topics in the future after the summer holidays. But thank you for now. Thank you to all the participants. Thank you to our co-organizers, to Olia Peneva from the Bulgarian Foundation for Business and Human Rights, and to all the interpreters who supported us so bravely and diligently across this 1.5 hour behind us. So thank you very much to everybody. And just to close with information that the recording will be available on YouTube. We probably will send out the links either end of this week or early next week. So thank you very much for now and have a good day. Thank you.
Thank you.